All right, good evening, everyone. I think we're practicing extreme social distancing here. For those of you at home, welcome. Hope you're enjoying the Zoom presentation. It's very good to be back in South Texas, actually seeing alumni. And hopefully we'll learn a thing or two today. The topic today is the Roberts Court, the past, the present, and the future of the Roberts Court. Let's start with some numbers. The first number is 6. For the first time in any of our lifetimes, the Supreme Court has 6 conservative justices. We need to go back to the New Deal, or perhaps even earlier, to count up to 6. But the real important number is not 6, it's 3. On paper, at least, we have a 6-3 conservative court. But in reality, the 9 justices divide into 3 camps of 3, what I call the 3-3-3 court. You have the court's 3 progressives, Justices Breyer, Sotomayor, and Kagan. And they vote pretty consistently as a liberal bloc, though that from time to time they sort of break up. Then you have the court's 3 most conservative members. You have Justices Thomas, Alito, and Gorsuch. They are the court's 3 most conservative members, and for the most part, they stick together. And then you have the 3 justices in the middle. Chief Justice Roberts, Justice Brett Kavanaugh, and Justice Amy Coney Barrett. These 3 members of the court are usually right-leaning, but from case to case, they may surprise. Now, it's not to say that these justices are moderate. Please don't get me wrong. My point is slightly different. It's that the center of the court has shifted to the right. And wherever the center of the court is, that's where Roberts, Kavanaugh, and Barrett find themselves, right? The phrase median justices mean they're in the middle of the political spectrum. They're just in the middle of where the court happens to be at this time. When Justice Kavanaugh replaced Justice Kennedy, he moved the middle of the court to the right. When Justice Barrett replaced Justice Ginsburg, the court moved even further to the right. Let's get some more numbers to think of. The next number to think about is 83. What's 83? Justice Breyers Age. Justice Breyer is the oldest member of the court. He's 83 years old. As far as we can tell, he's in good health. And he has made a conscious decision not to step down for a host of reasons. He can't quite articulate why, but he is not stepping down, at least now. Were he to do so, there's a slight Democratic majority in the Senate. And in theory, at least, President Biden's nominee could be replaced in short order. But as we know all too well, none of us know the day when we will die. It's a gruesome thought, but Justice Ginsburg died in office. Justice Scalia died in office. Chief Justice Rehnquist died in office. Many other justices have died in office. And I think it's very tricky to try to say, I will not die on this court, because, well, we never know when we will meet our maker. There's a sustained effort to get Justice Breyer to retire. I think those efforts will backfire and make him not retire because he doesn't want to look political. That's caving to pressure, but that is sort of where we are. The next number I want to mention is 55. 55. No, not the age. No. 55 is the number of signed opinions the court issued last year. Only 55 signed opinions. This is the second lowest total since the Civil War. The second lowest total since the Civil War. What was the lowest? The year before, the pandemic, that they only had 53 cases. So the court is deciding far fewer cases on the merits. They're deciding far more cases, though, on the so-called shadow docket. What is the shadow docket? It's a term created by Professor Will Bode at Chicago. It sounds very ominous and scary, but it's really not. All courts, not just the Supreme Court, all courts have a mechanism by which emergency appeals are heard. The classic example is a death penalty case. If the state has a death warrant to execute at midnight on a certain date, it's got to be resolved by midnight. And the Supreme Court has a mechanism to rush appeals to resolve promptly. Other cases go through the shadow docket in similar fashion. But during the COVID pandemic, and especially during the Trump years, the shadow docket got hot. In many cases, trial courts entered nationwide injunctions. And the Trump administration went to the Supreme Court to stop those injunctions. And sometimes they won, sometimes they lost. During the pandemic, which I think we're still during, can't quite count anymore, but during the pandemic, many states imposed restrictions on public gatherings, for example, houses of worship. Religious groups went to the Supreme Court in large number, seeking emergency relief. The court could have granted review and heard the case a year later, but these were sort of emergency policies that were only in existence for short periods of time. And invariably, the court said, we're going to resolve this now on an unargued basis without full briefing. So last year, depending how you count, there were a significant number of shadow docket opinions. Okay. The next number I want to mention is 6. How many cases were decided by a 5-4 basis last year? Only 6. So of the 55 cases, only 6 were 5-4. And they weren't all conservative. 3 went to the left and 2 went to the right. 1 was somewhere in the middle. How many cases were 6-3? 12. Now, the next number for you is 47. What percentage of the cases were unanimous last year? 47. Nearly half the cases last term were 9-0. If we throw in 8-1 cases, we're at 60%. So nearly 2/3 of the court's docket had 0 or 1 dissenting votes, which is not what you heard. The court has a lot of agreement. Of course, there are these sort of hot button issues that are very divisive. But these cases were in the minority. Who is now the median justice? I think the answer is Brett Kavanaugh. Last year, he was the majority 97% of the time. 97%, that is a lot. Chief Justice Roberts and Justice Barrett were the majority 91% of the time. So you can see these 3 really round out the court center. They are very rarely going to be in dissent. Who is in dissent the most? Justice Sotomayor, who is the majority only 69% of the time. Okay. Which justices were most likely to agree with each other? Chief Justice Roberts and Justice Brett Kavanaugh agreed 94% of the time. They were the best buddies. They seemed to get along quite well. Who disagreed the most? Justice Sotomayor and Justice Thomas. They agreed only 55% of the time. So they're the poles of where the court is right now. The court reversed lower courts 80% of the time. The Ninth Circuit did not fare well. Out of 16 cases, 15 were reversed. The Ninth Circuit has a 94% reversal rate, which is pretty high. The Sixth Circuit, perhaps lower, went 0 for 5. I guess that's batting 0, but 1 out of 15 sounds much worse. That is the sort of numbers to run down. I want to now walk through some of the more high-profile cases from last term. So first, let's start with the Trump cases. These were cases that involved the Trump administration, which were on the court's docket, but fell off sharply after President Trump left office. So for example, Wolf, the Innovation Law Lab, was a challenge to the Remain in Mexico policy. This case was granted cert in October. And after President Biden came to office, it dropped off the docket as moot. Next case, Trump versus New York. This case involved an attempt to modify the census to inquire about citizenship status. This case was granted and then dumped after President Trump left office. We have Trump v. Sierra Club. This case involved, if you remember, the border wall and emergency funding for it. Cert was granted, and you guessed it, it fell off the docket. Department of Justice versus House Committee on Judiciary. This involved efforts to obtain the Mueller grand jury materials. Remember that, right? Cert was granted in July of 2020. After the election, it fell off the docket, sensing a pattern here. So the number, the 55 number, was a bit lower because a lot of the Trump cases fell off, but still the court is deciding fewer and fewer cases. Now I'd like to walk through some of the highlights or lowlights, depending on your position, of the last term. Perhaps the biggest case that wasn't was California versus Texas, which was a challenge to the Affordable Care Act. It's a topic very near and dear to my heart. I've written several books on the topic. I've presented them at this very lectern before. The case was dismissed for lack of standing. The court held that when the penalty was reduced to $0, there was nothing to enjoin. There's no remedy to issue. Go away, Texas. You're done. And go away, Josh. So I got rejected just the same. My position got granted a total of 0 votes, so I must reconsider a lot of things. When I'm to the right Clarence Thomas, I think I gotta check my principles for it. Next big case was Fulton versus City of Philadelphia. Catholic Services in Philadelphia has been working with adoption and foster families for more than 2 centuries. Following the teachings of the Catholic Church, they will only place children in opposite-sex couples. They will not place children with same-sex couples or even unmarried couples. They focus on married couples who are the opposite sex. They sued the City of Philadelphia to challenge their non-discrimination policy. Was this case 5-4? Actually, no. Fulton split 9-0. Unanimous, 9-0. The court held that the city's policy was probably unconstitutional. Why do I say probably? The problem with 9-0 opinions is they leave a lot unsettled. Here's what the court said. Well, we know that the city can grant exemptions to other people, so why can't they grant an exemption to the church? Go back and reconsider anew why the church can't get an exemption from the non-discrimination ordinance. It also wasn't clear if this was actually being enforced. I sort of was very hesitant on the facts here. So this case was a 9-0 victory for the church. Unclear how long that victory lasts and how far it goes. But again, 9-0. Again, we have 3 justices, Thomas, Alito, and Gorsuch, who have gone further. They wanted the court to overrule a decision from 1990, Employment Division versus Smith. This was a case that afforded very deferential review to religious freedom claims. All right, the next case was not 9-0, it was 6-3 with a solid conservative majority. Americans for Prosperity versus Banta, B-O-N-T-A. He's the Attorney General for California. California required that all nonprofits disclose their donors to the state. And somehow, who knows how it happened, somehow that list was leaked to the internet. So all the people who supported various nonprofits had their information leaked on the internet. Go figure. This was a case that united left and right. The ACLU and the NRA were on the same side of a case. That doesn't happen often, but it happens. All nonprofits said we need to have privacy for donor lists. The state's interest is not compelling enough to require this to be disclosed. One of the leading precedents was NAACP versus Alabama in 1958. You may recall the state of Alabama demanded to know the NAACP's membership list for administrative purposes. Of course, that wasn't the reason. It was to intimidate the membership. The court, citing the Alabama case, said, no, you can't make the disclosure of donors. Query, though, what about other types of disclosure laws? The IRS requests the same information. Is the IRS policy now vulnerable? Stay tuned to a future term. The next case basically is Mean Girls. Mahanoy Area School District versus BL. BL, it was a minor, her name was Brandy Levy. She was now of age. Brandy Levy did not make the varsity cheerleading team, and she did what all teenagers did. She went on social media, and she said the F word, and she lifted up her middle finger in front of a Snapchat. She wasn't on campus when she sent these tweets or the Snapchat. She was off campus. Her school imposed punishment against her, and they would not allow her to participate in the activities. She was suspended from the JV squad. Okay. She sued, which is what all teenagers do when they get suspended from school. The case went through the courts, and the Supreme Court ruled for Brandy by an 8-1 vote. We'll get to the one in a minute. This was a extension of a very famous case called Tinker versus Des Moines from the 1970s, where the court said that your schoolhouse rights, right, your rights don't disappear at the schoolhouse door. The majority opinion was by Justice Breyer. It was very confusing and muddled. There are about a dozen factors that schools have to consider when they discipline students. Good luck, administrators. I don't know what the heck it means. Justice Thomas dissented. He's of the view that children have no rights at all in school, that parents are delegating to teachers their parental authority, and the teachers are in loco parentis, if I can bring it from Latin, and they can discipline as they see fit. So he would say this is an easy one. The school can discipline the child as they wish. I like the outcome of this case, but the analysis is so muddled. And I do wonder at some point, as more and more social media is incorporated into student existence, whether schools may have some interest in disciplining people. For the past year, we were basically living on Zoom. And to say that anything on Zoom is outside because you're not in the building perhaps goes too far. But this area is not done. Students will continue to litigate these issues. All right, let's do some separation of powers, kind of like this plexiglass divider, let's separate it from you. Let's talk about separation of powers. Collins versus Yellen. Yellen, she is the Secretary of the Treasury now. There's an agency which you've probably never heard of, the FHFA, the Federal Housing Finance Administration. It exists, who knew? It administers federal housing, go figure. It's headed by a single director who can only be removed for cause by the president. This person imposed various restrictions on businesses, and they transferred funds in ways that businesses didn't like. A challenge was brought saying that because this director is single, is only one, and he's protected from removal, the entire structure of the agency is unconstitutional. The Supreme Court ruled 9-0 that the agency is unconstitutionally structured. But the court did not invalidate the entire agency. Rather, the court simply said, well, the way to cure this is simply allow the president to fire the director for cause. I'm sorry, or the president can fire the director without cause. What did Joe Biden do? He fired the director as soon as this case came out. So this is a case where a so-called conservative victory gave a Democratic president a short-term win. Another case, United States versus Arthrex, A-R-T-H-R-E-X, Arthrex. This case involved patent judges. And the question was whether patent judges were constitutionally appointed because they cannot be removed by the president. Here, the court basically said, well, these judges are not constitutionally appointed, but we can make things better by having them subject to removal by the director who's appointed by the president. It was a very weird holding. I don't like it. But the court sort of said, yeah, it's unconstitutional, but nothing will change. We made up a remedy. Judges should not be creative, right? If you're a judge, you're getting creative, you're doing something wrong. You should be boring. Judges should be very boring always. I don't like when judges make stuff up. By the way, John Roberts wrote the majority opinion. He gets very creative. Judges should not get creative. Makes me annoyed. Let's move on to election law. Election law. We had an election this past term, seems to never end. It's still going on. Brnovich versus DNC. This is a case from Arizona. Arizona implemented two restrictions and regulations. One involved voting. If you vote in the wrong precinct, your vote's thrown out. The second involves ballot collection. Only certain people can handle ballots. For example, family, household, caregivers, mail carriers. You could not hire people to go door to door to collect ballots. Both of these measures were challenged as violations of the Voting Rights Act. The argument was that these restrictions imposed additional burdens, particularly on minority voters who might not be able to comply. Arizona is a high native population. They live in reservations that are quite removed from people, and they may not be able to have a family member carry their ballot. There were people whose job was to go and collect ballots from people from the tribal members living on these various reservations. This case again split hard 6-3. The court's conservatives said that this was fine. Justice Sam Alito wrote the majority opinion. And Justice Alito acknowledged that there's some burdens in voting, but he said everything has burdens, right? You can't have a process without any burdens. If you want to mail in a ballot, you need to pay for a stamp. That's about 40-something cents. And these are just part of the cost of doing business. Justice Kagan wrote a very, 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 very vituperative dissent. And she argued that this is not how voting law should work. And the court should not stand by as restrictions on the ballot were made. Now, the Arizona case, restrictions were actually fairly mild. They pale in comparison to some of the other restrictions adopted by Texas, Georgia, and other states. But the court here signaled for the other cases that they'll be fine, right? This was a pretty clear indication that voting rights challenges will not find redress in the courts. Unless Congress enacts new legislation, I think under the existing law, states will have fairly broad leeway to enact these various voting laws. Okay, let's do some Fourth Amendment cases, some criminal procedure stuff. Lang versus California. You had a guy whose name was Arthur Lang. He was driving erratically, and the cops were following him. Lang pulls into his garage. The cops pull up behind him. They gave him a sobriety test. Again, he was in his garage. And they arrested him for DUI. Lang moved to suppress the evidence because he argued it was a warrantless search. They entered his home without a warrant. If they'd done the search on the street, no big deal, you're in a public place. But they followed him into his garage, where arguably it was perhaps safer to do a DUI test than on the side of a highway. The Court of Appeals held that if there was an exigent circumstance, then you could always follow a suspected misdemeanor into his home. The Supreme Court ruled 9-0 here, although the court was pretty fractured beyond that. Justice Kagan wrote the opinion. She said that pursuit of a fleeing suspect does not always justify warrantless entry into a home. Unfortunately, we have another balancing test. Justice Kagan said whether a misdemeanor pursuit involves exigent circumstances turns on the particular facts of the case. And then the court remanded for further consideration. So we don't even know if this particular search was valid, but the court said there's no bright line rule, that there has to be some sort of balancing test that goes on. Okay. Let's talk about Section 1983, which involves civil rights suits. This next case is crazy. Torres versus Madrid. This case, it was written for a law school fact pattern. So you have two cops who enter an apartment complex, and they're trying to execute a search warrant. They see a woman in the parking lot. At the time, she was going through meth withdrawal. She was not in the right state of mind. Now, she wasn't the person they were looking for in the search warrant. They just saw this woman who was acting very weird. They call out to her and they say, stop. She thinks they're robbers, right? They're not in uniform. So she gets into her car and the cops draw their guns. At this point, the woman, Torres, thinks she's getting carjacked. So what does she do? She slams on the gas and drives away. The cops open fire as she's driving away, and they fire several rounds into her back. Now, most people, if you shoot them in the back, they stop, but not Wonder Woman over here. She keeps going. In fact, she was paralyzed in her left arm. She was driving with her left arm while having bullets in her back. I don't know how she did it. She drove 80 miles with one arm while being paralyzed with the other arm. She actually made it to a hospital, and she checked herself in. Amazing, right? She later filed suit against the officers for violating her rights under the Fourth Amendment. She argued there was an illegal seizure of her person. Seizure, that's the word in the Fourth Amendment. But there's an important question. Is there a seizure if you're not stopped? Is there a seizure if you keep going? Right? In order to be seized, you have to be stopped. The court split here 5-3. Chief Justice Roberts wrote the majority. Justice Gorsuch wrote the dissent. Justice Barrett did not participate. She wasn't on the court yet, but her vote would have mattered. Maybe it would, who knows. The chief held that you can have a seizure even if the suspect eludes capture. Right? You can have a seizure even if the suspect eludes capture. The application of physical force to the body of a person with intent to restrain is a seizure, even if the force does not succeed in subduing the person. The chief wrote, at common law, a mere touch, even if unsuccessful, would have resulted in a seizure. So if you shoot someone, they don't stop, but the bullet hits them, that is enough for a seizure. The dissent by Justice Gorsuch said this makes no sense. How can you be both seized and in motion? You can be only one or the other, right? To seize requires taking possession, and instead the majority confused a seizure with battery. The dissent says that cannot sustain itself. I think this was actually a really close case. I'm actually with the dissent, but barely. I think this is a really close case, really close case. Let's talk about antitrust. NCAA versus Alston. This case involves student athletes. For the longest time, the NCAA prohibited, or at least restricted, compensation for so-called student athletes. These athletes would participate in sports that would generate millions, billions of dollars for the industry. And the students got, basically nothing. They would get tuition, they get room and board, which is nice. They might get a modest stipend, but they couldn't cash in. The court held that the NCAA could not enforce this restriction against student athletes, right? The court did not enjoin all restrictions on student athletes, but the writing was on the wall. Justice Kavanaugh, who's a bit of a sports fan, said the NCAA's rules raise serious questions under antitrust laws. And almost immediately after this decision, the NCAA changed course. Now student athletes are permitted to cash in under name, image, and likeness. So if a student wants to sign a jersey with their name on it, they can do that. If the student wants to sign autographs and charge a fee, they can do that. A lot of athletes now are getting sponsorships where they have to, post stuff on social media, and they're getting paid to do this, right? I don't know where all this leads. Student athletics may change in ways that aren't quite obvious, but this is a brave new world for student athletes. Okay. The next big case from last term is a property case. I teach property. If you have seen me, former students watching, you may have had me. The court's takings cases are a mess, right? The Fifth Amendment says if the government wants to take your property, they have to pay you just compensation. But it doesn't say what a taking is, what it means to take property. They had a case last term called Cedar Point Nursery versus Hassid, HASSID. This case comes from California. Cedar Point involved a union law. California required farmers to allow union organizers onto their property for up to 3 hours a day, 120 days a year. The farmers argued that this rule was a taking, that it took their property, because the most important stick in the bundle, you remember, is the right to exclude. And requiring them to allow these organizers to their property was unconstitutional. The Supreme Court agreed 6-3. Chief Justice Roberts wrote the majority opinion. This is probably the most strongly worded property decision I've ever read by a Supreme Court justice. Roberts, as he often does, got creative, and he took different strands of property theory and merged them together. And he created a test that makes it very hard, or depends who you are, but very easy for property owners to win with. This is probably the most significant case in property law in decades. The courts, conservatives are somewhat over the map, but on property rights, they are locked in. So when I teach this case in class this year, I'll tell my students, forget everything you know, right? All this stuff that happened before, this is the new standard, right? This is what you have to work with, because the court has really shifted how it approaches a takings clause. All right, that's all I want to say about last term. Let's move on to next term, which starts 1 week from today, the October 2021 term. My friends, this is probably the most significant term since I've been in grade school. The number of huge cases here is frankly stunning. We have everything. We have abortion, we have guns, we have affirmative action, we have religious freedom. We'll have COVID cases, we probably have an election litigation, we have redistricting, right? There are so many live issues. When I say live, I mean they're hot. These are not issues that have been simmering for years. These are live issues that need to be resolved now. Okay? So let's walk through some of these big cases. First, let's do the Second Amendment. New York State Rifle and Pistol Association versus Bruin, B-R-U-E-N. This case considers whether the Second Amendment protects the right to keep and bear arms outside the home. In 2008, the court decided DC v. Heller. This case considered whether you have the right to have a gun in your house. And the court went a full decade without deciding what else the Second Amendment protects. We have the case now. The court denied cert in many, many cases, which leads me to believe that there's some doubt over how the court would rule. But now with Justice Barrett on the court, maybe there's a fifth vote, or maybe not. I don't make any predictions on gun stuff because I'm usually wrong. I'm usually wrong in everything. My predictions are terrible, by the way, so ignore everything I've said so far. But the biggest case on the docket this year, by far, is Dobbs versus Jackson Women's Health. This is a case from Mississippi. Mississippi enacted an abortion ban that bans abortions after the 15-week mark. 15 weeks, if you don't know, is before the point of viability. And under the court's precedents, abortions are generally not banned prior to the viability line. This is under Casey and other cases like that. So this law is basically a frontal challenge to the Casey test. The plaintiffs, Mississippi is not hiding their ball. They say they want to overrule Roe v. Wade. They say it quite clearly. In fact, I think the only way to uphold this law is to overrule Roe. The government agrees. So either you overrule Roe and you uphold this law, or you sustain Roe and you strike this law down. I think those are the choices. Complicating, perhaps, this case is the Texas abortion case, which is lingering in the lower courts now, but will shoot up quite quickly. This is SB 8. Texas enacted a law that restricts abortions after the point of cardiac activity, which is roughly 6 weeks. but it does it in a weird way. It allows private citizens to sue. The upshot of this law is it's very hard to challenge. Right? The only way to challenge this law is to wait to be sued and raise your defense. The United States has actually sued Texas, and not just Texas, you, and you. We are all defendants. You didn't know this. But because every Texan is a potential plaintiff, you are all defendants. Congratulations. We'll get so you get your fees paid. You've all been sued, right? DOJ argues that an injunction issued against everyone in Texas, really everyone around the world, it's a global injunction, stunning in its breadth. And they sought this from a federal court. I suspect the Texas abortion case will get to the Supreme Court by Thanksgiving, maybe Christmas, but it'll be soon. So the court will have to decide the Mississippi case and the Texas case in the same term, which is, again, significant. The court hasn't actually had 5 potential votes to rule Roe since the early 1990s. And here we are. We have some school choice issues. Carson versus Macon. This is a forever thorny issue, whether states can provide various tax credits to private schools, but exclude religious schools from the scope of those credits. Last term, the court had a case called Espinoza versus Montana Department of Revenue. Espinoza held that you can't discriminate against religious schools. This term we have a case, Carson versus Macon, M-A-K-I-N. And I think this case will hold the same, that you can't deny funding to religious schools simply because they use the money for religious purposes. I think that follows from Espinoza. Okay. We got some criminal procedure. United States versus Tsarnaev. Remember that name? So you may remember some years ago that the Boston Marathon, there were the 2 brothers, the Tsarnaev brothers. They inflicted mass fatalities at the finish line. They constructed these IEDs, basically a pressure cooker filled with ball bearings and other types of shrapnel, and exploded this at the finish line on the Boston Marathon. A horrible, horrible, horrible event. One of the brothers was actually killed during the pursuit. I think he was actually run over by his brother, among other things. The other brother survived somehow. He was sentenced to capital murder on countless murder and other charges using terrorist explosive devices, just gruesome facts. The First Circuit, the Court of Appeals, threw out his capital sentence. The court said that the district court didn't do its job correctly. For example, voir dire, or I should say in Texas, voir dire, was messed up. The judge didn't ask each juror for a specific accounting of the pretrial media coverage he or she consumed. So in other words, he asked generally, what kind of media did you watch? But he didn't ask each member of the jury pool, the veneer, I guess, right, what they thought. These are fairly technical issues with sweeping consequences. Also, the district court excluded evidence that the older brother was involved in different crimes years earlier, sort of mitigating evidence. This is the brother who didn't survive. Complicating this further is the Biden administration has put a stop on executions. So Biden's in a weird spot. He's defending a death sentence he doesn't want to carry out. It's a very weird position to be in. In fact, I half expected Biden to try and say dismiss the appeal, but I think they're going forward with this one. This is a very, especially if you're in Massachusetts in that area, this is a very a weighty case for the people there because it's such pain for the community. Another case involves our fair city, Houston Community College versus Wilson. And I got to tell you, we got a treat if you don't already know. One of our own alumni is actually going to argue this case. Isn't that cool? Yeah, I know the school's doing it right. They're having it's a documentary. Yeah, the dean's nodding. But the school's doing this right. They're actually doing a documentary. Richard Morris, who's an attorney here in town, is going to be arguing the case later this term. And the school's doing a little documentary. We have our students who are helping him. He doesn't need help, but our students are actually helping to prepare for his argument. It's actually a really unique experience, and we're very proud. We're doing a moot for him. Some of our colleagues are doing it, so we're really excited. One just know the argument. The Supreme Court for the past year and a half has basically been on Zoom like everyone else. They adopted a very annoying format. Rather than having a free-for-all where everyone just asks questions at once, they would take turns. So Chief Justice Roberts would have 2 minutes, then Justice Thomas would have 2 minutes, then Justice Breyer would have 2 minutes. And I'm telling you, the chief would cut you off mid-sentence. He would actually cut you off at the US Supreme Court, can you imagine? But that's what they did with Zoom. And it wasn't on video, it was just telephone. The upshot, though, is they actually live streamed the audio into C-SPAN, which I think was a huge improvement over the past. This year, they're doing something different. The court will be in person, the advocates will be in person, there'll be a few reporters there, and that's it. So in the huge Supreme Court chamber, it fits about 500 people. There might be 30 or 40 people at the size of this room, maybe. It'll be pretty sparse, right? They're still going to allow the seriatim questioning. So at first, they'll have the normal argument. And when the arguments are over, each justice will have a chance to ask questions one-on-one. So it's this weird hybrid approach. It's a free-for-all and then structure. We suspect this is to help Justice Thomas, who does not like to ask argument questions because he doesn't like to fight for time. He says they're a waste of time. But during the Zoom arguments, he was quite aggressive with questioning. I think very effective. So I think this is a sop for Justice Thomas. Maybe things will go back to normal eventually, but who knows? Anyway, the Houston Community College system versus Wilson. This case presents a question whether the First Amendment restricts the authority of an elected body to issue a censure resolution in response to a member's speech. So who's Wilson? David Wilson is a bit of a gadfly. Is that fair, Dean? I think that's fair. Okay, shaking his head. He's a rabble rouser. He's a member of the community college board, and he likes to stir up trouble. He's written various things critical of the organization he's a member of. He's done investigation. He's kind of annoyed people, gotten their bad side, kind of like me, I suppose. But he's an elected member, and his board issued a censure resolution. They didn't fire him or remove him. They issued a censure. And the question is, does that censure violate Wilson's free speech rights? The Fifth Circuit actually ruled in favor of Wilson. So HCC filed a notice of appeal. Certiorari was granted, and our own Richard Morris will be arguing the case. The general rule is the Supreme Court reverses when they take a case, 80% reversal. I think his odds are pretty decent to win, but I think you'll have some good South Texas vibes, and hopefully he'll enjoy his time with it. Even if it's empty, there's just no one there but the press, but he'll enjoy his time there, I hope. A couple more cases. State secret privilege. This is a case from the Ninth Circuit, United States versus Zubaida. This has to do with national security and whether certain CIA contractors and they collected activity, can those be produced in litigation? Let me just jump ahead to one case that's not on the docket, running a little bit short in time, is affirmative action. Students for Fair Housing versus Harvard. You may remember from common law, there was a very important affirmative action case from the 1970s called Bakke, B-A-K-K-E. And then in the early 2000s, another case called Gruder and Grass from Michigan. And more recently, a case from Texas, UT Austin versus Fisher. So all these cases were written with a fairly sympathetic bench for affirmative action. That doesn't exist anymore. The court's conservatives are pretty hostile to affirmative action. Students for fair admission involves not a public school, but a private school. Wait a minute, Josh, wait a minute. I remember 14th Amendment. Doesn't the 14th Amendment limit only state action? Yeah. But then you have Title VI, the Civil Rights Act. If you are a institution of education and you accept federal money, which almost all of them do, I think we do here, paying my salary in part, you must comply with federal law. And one of the conditions of Title VI is you cannot discriminate on the basis of race. So these are not 14th Amendment cases, these are Title VI cases. Harvard, you may have heard of the school in Cambridge. They have a law school as well, it's pretty old. Harvard has a racial admission policy that depresses the number of Asian students who are admitted. I'm being charitable. If you look at the entry standards for certain races, it's very skewed. The lower court upheld the policy. This case went to the Supreme Court. The court asked for the views of the Biden administration. Shocker, we know what they're going to say. It's kind of a delay tactic. So either this year or next year we'll get affirmative action. The court may decide we don't want to do guns, abortion, and affirmative action. Maybe they spread it out. But I think this case will come up very soon. Those are all the cases I want to talk about, but 10 minutes left. Questions, either in person or on Zoom. I'm sure I can see the chat on this lovely South Texas designed Zoom interface. Okay. Questions from you all. If you don't, I can keep talking, but I'll make sure it's time for Q&A. Yes, in the back. And would you say your name, please?
My name is Christine Heron, and I'm an alumni. And I was just wondering what case you are going to find most interesting that's coming up. Like, which one do you think will have the most significance to us, kind of, that's coming?
Oh, it's a good question. You know, I think probably one of the election cases might be more significant, involving redistricting. These cases are fly under the radar, but become very important in election years. Probably one of the election cases is probably the most significant, if I had to guess. Good question. Other questions? On Zoom?
Josh, the Zoom questions because of the setup are not.
Oh, I see. Well, I'll imagine questions. I can talk a little bit more. Okay. So one of the themes of this court is you're sort of operating in a weird political environment. After Justice Scalia died and Justice Gorsuch was put in his place, and Merrick Garland never even got a hearing, there was a movement to reform the court, expand, if you will. And after Justice Ginsburg died suddenly, and a nominee was put on in the span of about 20-something days, the movement to expand the court was increased further. President Biden appointed a commission to study reforming the Supreme Court. And that commission is putting together its report. There are shades of history here. The court has gone through sort of attack before. President Roosevelt famously tried to expand the court. I don't think there's the political will to actually go ahead with expanding the court. I don't think it's present, at least not in the current Congress. But you still have to worry that at some point the justices may worry about that outcome and may decide to modify their opinions. I think that's the true justification for these efforts of court reform. It's not to actually change the court, but it's to sort of cow the court into doing things more to their liking. So as we see the court's decisions here, I think we have to keep in mind that this threat is lurking in the background, even if the threat is quite empty. Okay. Any other questions? No? Thank you all so much. Thank you for coming.